I'm Brett Panter from the Personal Injury and Medical Malpractice Law firm of Panter and Sampedro. Here today to talk to you about Florida caps on damages. Caps on damages related to medical malpractice cases were instituted in 2003 by the Florida legislature. We as trial lawyers and consumer advocates felt that they were arbitrary. They limited non-economic damages to $500,000 per claimant and practitioner. But in 2005, the McCall versus United States of America case began. That case involved Michelle McCall, who was a young woman who had prenatal care at the Air Force Clinic. She had high blood pressure that required her labor to be induced. She remained at a family practice department instead of being transferred to the OBGYN department where she needed an emergent C-section to help her and her baby. An obstetrician was not available for a cesarean section, so she had a vaginal delivery and fortunately had a healthy boy. But her, the mom herself, had severe blood loss and death, and she was removed from life support, and her family and her young child had to go without a mother and a wife. The court found that the non-economic damages in this catastrophic case merited a judgment of $2 million, but felt that they had to reduce that judgment because of the Florida caps from the 2003 legislation. The legal question ultimately ended up in the Florida Supreme Court, and the question for the court was, does the medical malpractice statute of 2003 violate the Florida Constitution on equal protection bases, access to courts, rights to trial by jury, and separation of powers? The Supreme Court finally gave us an opinion last year and found that Florida Statute 766.118 did indeed violate the Equal Protection Clause of the Florida Constitution. The court found that it arbitrarily diminished the compensation for legally recognizable and cognizable claims. This was a very important decision and part of the fight that we as lawyers are involved in to help get proper and adequate compensation for our clients.